It's a normal Tuesday. You're doing your job well, but suddenly you're called in, fired with zero explanation, and packing a box. People often assume their boss needs a legitimate reason to let them go, but the legal default in 49 out of 50 U.S. states, everywhere except Montana, is a doctrine called at-will employment. This doctrine means an employer can terminate your employment for a good reason, a highly unfair reason, or absolutely no reason at all. It is entirely legal to fire you simply because they do not like your shoes. There is, however, a strict boundary line. While your boss doesn't need a good reason to hand you a pink slip, they are strictly prohibited from using an illegal reason. Crossing that line changes the entire legal landscape. The first major exception comes from the doctrine of federal preemption. Thanks to the Constitution's supremacy clause, when a federal law conflicts with a state rule, like at-will employment, the federal law crushes it. The most robust example is Title VII of the Civil Rights Act, which explicitly bans firing individuals based on race, religion, sex, or national origin. We see this applied directly in a notable 10th Circuit Federal Appeals Court case. The court ruled that an employee fired for missing work on Wednesday afternoons to observe her religion had a valid claim under Title VII. The at-will doctrine could not protect the employer's discrimination. Federal law classifies religious discrimination as a civil rights violation, ensuring these protections remain active the moment an employee clocks in. However, the default rules for termination dramatically shift the moment we look at situations where the employer is a government entity. Section 1983 allows citizens to sue anyone acting under color of state law who deprives them of constitutional rights. This shields public whistleblowers. If an official fires an employee for exposing corruption, they violate the First Amendment and can be held personally liable. For those working in the public sector, the U.S. Constitution itself overrides the state-level at-will doctrine, stripping rogue managers of the absolute power they might think they wield. Back in the private sector, there is a final, highly common exception: contract law. If you have an explicit employment contract that requires good cause for termination, the at-will default is entirely voided. You don't always need a formal signed agreement to get this protection. Many employers accidentally waive their at-will rights through implied contracts. Internal rules can become legally binding promises. If a handbook outlines progressive discipline, requiring a verbal, then written warning before termination, that creates an implied contract. A manager cannot bypass those steps to fire you. Extensive handbooks intended to regulate a workforce frequently end up dismantling the very at-will power the employer sought to protect. The at-will shield is fragile. Knowing this, you are now equipped to investigate your own firing for hidden illegalities. Suspicious timing reveals the truth. Terminations immediately after FMLA leave or safety reports suggest illegal retaliation. Shifting explanations, from budget cuts to poor performance, signal a cover-up. Lastly, disparate treatment, firing one person for a minor infraction while others face zero consequences. Employers wield immense default power over our livelihoods, but these federal, constitutional, and contractual boundaries exist to check that power and level the playing field. Identifying these patterns is only the beginning. Because these are complex legal matters rather than simple observations, those who recognize these signs should consult an employment attorney.